Intellectual property is the legal framework that treats creations of the mind as assets that can be owned, licensed, sold, or protected. Think of it as a set of tools that turns creative effort and innovation into something you can control commercially. A song, a logo, a software algorithm, or a secret formula. All become assets that influence how competitors, customers, or collaborators can use them. At its core, IP answers two practical questions every creator faces: who has the right to use this work, and under what conditions, and gives you legal mechanisms to enforce those answers when someone else copies or misuses your creation. The reason IP matters in business is straightforward. Without clear ownership or protection, others can replicate your work, erode your market advantage, and undercut your ability to earn from what you built. IP protection is not only about lawsuits, it's about control and choice, whether to keep something confidential, to register rights to gain enforcement power, or to license it out for revenue. A smart IP strategy aligns legal choices with your commercial plan. Sometimes secrecy is better. Sometimes registration is worth the cost. And sometimes a mix of rights suits different pieces of the same project. Practically, begin by identifying what you actually created and documenting it carefully. Dated drafts, emails, prototypes, and version histories matter more than you might think. Record keeping builds your story of creation and helps enormously if you later need to show when and how something was developed. Finally, ask yourself how likely it is that others could copy the work easily, how much commercial harm copying would cause, and how much you are willing to invest to prevent that harm. Those answers should guide whether you file for formal protection, tighten internal security, or rely on brand building and speed to market.